Juvenile Justice, Care and Protection of Children Act 2015. Introduction. This act came into force from January 2016 and repeals the Juvenile Justice Act 2000. The Juvenile Justice Act 2015 provides for a strengthened provision for both the children in need of care, protection, and children in conflict with the law. The law intends to act as a deterrent for child offenders committing heinous crimes such as rape and murder and protect the right of the victim. Definition. Child, a person who has not completed 18 years of age. Child in conflict with law, a child who is alleged to have committed an offense and has not completed 18 years of age on the date of commission of such offense. Petty offense, offense for which the punishment is imprisonment up to 3 years under the IPC. Serious offenses for which the punishment is imprisonment for from 3 to 7 years. Heinous offenses, offense for which the punishment is imprisonment for 7 years or more. Juvenile Justice Board. A board to try offenders should consist of a judicial magistrate of first class metropolitan magistrate with at least 3 years experience and 2 social workers, out of whom at least one should be a woman. They will form a bench and have the power of judicial magistrate of the first class, and magistrate on the board is designated as the principal magistrate. Order that may be passed if a child is found guilty of an offence, sent home after advice or admonition and counseling to the parent, guardian, and the juvenile. Participate in a group counseling. Perform community services. Pay fine, either by the parent or the juvenile. If he is over 14 years of age and earns money, release on probation of good conduct and placed under the care of any parent, guardian after executing a bond, with or without surety or any fit institution for the good behavior and well-being of the juvenile for a period not exceeding 3 years. Sent to a special home reformatory school, formerly called as a borstal, for a period of 3 years. Several rehabilitation and social reintegration services measures have been provided. Under the institutional care, children are provided with various services including education, health, nutrition, de-addiction, treatment of disease, vocational training, skill development, life skill education, counseling, etc., to help them assume a constructive role in the society. Non-institutional options include sponsorship and foster care, including group foster care for placing child in a family environment which is other than a child's biologically family. Heinous crimes offence committed by child above 16 years. Child in the age group of 16 to 18 years may be tried as adult in case of heinous crimes after preliminary assessment by psychologists or psychosocial workers or other expert with regard to his mental and physical ability to commit such offences. Ability to understand the consequences of the offence and the circumstances in which he allegedly committed the offence should be done. Board can transfer such cases to a children's court of session. The provision provided for placing children in a place of safety both during and after the trial till they attain the age of 21 years, after which an evaluation should be conducted by the children's court. After the evaluation, the child is either released on probation, and if the child is not reformed, then the child will send it to a jail for remaining term. Age determination. If it is obvious based on the appearances that the said person is a child, then the trial proceeds without waiting for further confirmation of the age. In case there is doubt regarding whether the person is a child or not, then age determination is done using the following evidences: date of birth certificate from the school or the articulation certificate and its absence birth certificate given by a Corporation, municipal authority or panchayat. In the absence of any of the above, age shall be determined by an ossification test or any other latest medical age determination test. Adoption of an orphan, abandoned and surrendered children. To streamline adoption procedures for orphan, abandoned and surrendered children, the existing Central Adoption Resources Authority is given the status of a statutory body to enable it to perform its function more effectively. It provides for a detailed provision relating to adoption and punishment for not complying with the laid down procedure. The process have been streamlined with the timelines for both in country and inter-country adoption, including declaring a child legally free for adoption. As per the provision, a single or divorced person can also adopt, but a single male cannot adopt a single girl child. Inclusion of new offences committed against children. Several new offences committed against children: sale and procurement of children for any purpose, including illegal adoption, corporal punishment in children care institution, use of child by militant group, offences against disabled children, and kidnapping, abduction of children are included in the act. Penalty for cruelty against a child, offering a narcotic substance to a child, abduction and or selling a child have been prescribed. Penalty for non-registration of child care institution is imprisonment up to 1 year, with or without fine up to 1 lakh. Penalty for giving a child intoxicating liquor, narcotic or psychotropic substance is imprisonment up to 7 years, with or without fine of 1 lakh rupees. Prohibition on disclosure of identity of children. The name, address, school, photograph or any other particular of child in conflict with the law or victim or witness of a crime should not be disclosed in the newspaper, magazine or audiovisual media. Disclosure may be permitted if it is in the best interest of the child. The police should not disclose any record of the child for the purposes of character certificate or otherwise in cases where the case has been closed or disposed of. Any person contravening the provision may be punished with imprisonment for a term which may extend to 6 months with or without fine up to 2 lakh. Thank you.